All right, so we are back today together, and I just wanted to do a hygiene check. Chetna, is my voice audible? Am I visible?
Yes, ma'am.
Okay, cool. So we've got a very important topic to discuss today. There have been a lot of requests that what has happened in the recent past, very recent past, about setting up of intellectual property division and any changes in the Patent Act, and how are we going to respond to the answers to the questions which are hinted towards Intellectual Property Appellate Board, which doesn't exist anymore, and would there be any questions related to Intellectual Property Division, and also the rules which have been published in this regard. So I thought we'll do a small session regarding this, and we all will discuss what has been the changes. And then after this live streaming is done, I think Chetna will be sharing with you the class link, and during the class we'll discuss all of this quite in detail. Okay, so let's get started. So we will be covering three things today. One is the Delhi High Court Intellectual Property Division Rules 2022. We will also discuss High Court of Delhi rules, which are governing the patent suits 2022. So there are two rules which have been published by the Delhi High Court. The first one, as I already mentioned to you, it is more related to the overall rules with regard to any sort of intellectual property matter that will be henceforth uh, taken to the Delhi High Court. And the second set of rules, which is this one, is more specifically related only to the patent suits. Okay, so anything with regard to how the written statement has to be filed once the plaintiff has filed his plaint, and how the replication of application has to be filed, all with regard to the patent disputes. Those are the rules which are the second one that we will discuss. And then last, we will discuss about the patent amendment rules 2020 and 2021, which is where we'll discuss very briefly about the changes with regard to academic institutions, the filing fee, and the Indian startups and the expedited examination. Okay, so we will keep this session very brief, and my aim is just to take you through what has happened in the past. Once you have a historical background, I can assure you that it won't be difficult for you at all to it won't be difficult for you to respond to the answers, respond to the questions that you may get on 8th of May when you will sit for your patent agent examination. Okay, so let me know if somewhere you lose me or my voice doesn't remain as audible. Please feel free to put it in the online chat, and it will be taken care of. Just 1 second. Okay, so let us now discuss about Delhi High Court Intellectual Property Right Divisions Rule. So this is the rules which are more related to the Delhi High Court, and with regard to anything, any sort of an IPR matter that will be filed at the Delhi High Court. So timelines of events, let us look at some timelines which have happened with regard to Intellectual Property Appellate Board and Delhi High Court IPD, which is Intellectual Property Division. So I won't call each time Intellectual Property Division. We'll call it in abbreviation IPD. Okay. So what happened on 15th September 2003 was that Intellectual Property Appellate Board was instituted. And please take care of these timelines that I'm telling you, because during the Viva, you might be asked about these questions. Okay. So these timelines are important from Viva point of view, and you may get very small questions with regard to 1 mark question as far as these timelines are concerned. So IPAB was instituted to hear appeals against the registrar for the trademark and GI only, and this happened on 15 September 2003. Later on 2nd April 2007, the scope of the patent appeal matters, that is the power to handle appeals, was shifted also from the High Court to the Intellectual Property Board, Appellate Board. Why? Because this was already an Appellate Board set up to take care of the matters related to trademark and GI. This had appropriate number of right relevant stakeholders. So it may have been thought that okay, let us take away everything from the Delhi High Court. Let all the matters go to the IPAB first. So this is what happened between 2003 to 2007, and finally in 2007, the appeal related to patent matters was then shifted to IPAB from Delhi High Court. And then on 1st April 2017, which is almost after 10 years, the scope was further extended, right? To even uh, enhance the scope of Intellectual Property Appellate Board to start hearing the matters related to copyright. Now, why all of this was happening and the scope of IPAB was extended? Because also a few years back, the copyright related division, which used to be under Ministry of Education, it was shifted from Ministry of Education to DPIT, which is under Ministry of Commerce and Industry, that takes care of all other IPR matters. So everything was into a consolidation, right? So government, the policymakers, executive bodies, they were thinking it is a good idea to keep everything under one common ministry and one common appellate board. And therefore, you would have seen, as I'm explaining to you, from 2003 to 7 to 2017, the scope of IPAB just continued to increase. Then what happened on 1st April 2021, 2021 was IPAB functions were transferred back to the High Court and the commercial courts. And the reason has been because there have been a lot of lobbying, there has been a lot of advocacy by certain set of stakeholders who said that IPAB is not functioning very well because either the chairman was not appointed or there were no appropriate number of members who could handle the cases very well. So these were the contentions from one set of lobbyists or advocates, advocacy group people. But the other set always felt that no, IPAB is perfect and all it needs is to strengthen it more. But finally, Government of India thought that it's better to close Intellectual Property Appellate Board, and this closure happened under one of the ordinance which was passed, and this ordinance is called as the Tribunal Reforms or the Rationalization and Conditions of Services Ordinance 2021. In this ordinance, if you look at the whole list or the whole details of it, the government was talking about different set of appellate boards which exist for different laws and different sectors, and how many of those appellate boards are actually functional, or they were discussing how many are actually defunct, they've not been working, or is there any way that some of those can be closed and the exchequer could be saved, because certainly there is a money that goes into functioning of these appellate boards. So finally, under the Rationalization Act or the Ordinance 2021, IPAB was finally closed. Since IPAB was closed, now anything that has been handled by IPAB had to be now shifted to Delhi High Court, or in fact, there are other high courts which also have to come up with their own set of rules. 24th Feb 2020-22, Delhi High Court notified this Intellectual Property Division, because certainly if there is no IPAB, where would the matters go? Where would the original cases be filed, suits be filed? Where would the appeals go out of the decisions of the controller? So if controller has given us decision and someone is not happy with the decision, where would it go? So Delhi High Court set up an Intellectual Property Division. Okay, and this happened under the rules which were published in 2022. So these are the timelines. I think you should take a snapshot of this, or maybe pause the video at a later stage when you view the recordings. And be careful, be mindful of the historical significance and what has happened over a period of time. I think it will be good if you are able to explain it better during your Viva also. And I'm sure that this is so fresh a thing. During Viva, many of you may be asked about this question. So if you have these nuances, these ideas, I think you'll be able to very nicely explain it. Now, going forward, the jurisdiction of Delhi High Court regarding Patents Act 1970. Now, the questions which are being asked during the classes, during the batch, is that what will happen to different sections in the Patent Act? Are they also not going to be taken care of anymore, or would there be any change suggested? So the act remains intact. Okay, there is no change in the act, it is intact. The only difference is wherever you find the word Intellectual Property Appellate Board, read it now as Delhi High Court. That is it. All other things remains the same. So let's say if there is a question in the question paper in the upcoming patent agent exam, where they say that, okay, if there is a case with regard to invalidation, or there is a revocation as a result of counterclaim in case of infringement, where will it go? So instead of IPAB, if there is a decision of the controller, that against the decision of the controller, you have to now go to the High Court straight and not to the IPAB anymore. That's the only difference that has happened, right? So prepare as you've been preparing and as you've been reading your BEAR Act. Anyway, let's go forward and see what has happened. So Delhi High Court Intellectual Property Division has been set up. It has two sort of jurisdictions. Okay, one is the original side and another is the appellate side. What does it mean? What is original and what is appellate? Okay, so original is something which you first time straight away go to the court and ask for a relief, and there has been no prior or earlier decision of any lower authority. Okay, suppose there is a patent that has been granted, and once it has been granted, you want to revoke it, let's say on its 10th year or on its 11th year or whatever, and so there is no already there is no authority that has decided on its invalidation or something. So when you go straight to the court, that is called as original jurisdiction, which means there is no other authority that has ever earlier decided on any matter, and you are going straight to the court to ask for a relief. Under the original jurisdiction, there are only two sections, right, which will be taken care of, which is section 64. And section 64 is what you all know, right? We've read it very deeply in the classes also. Section 64 is with regard to the revocation of the patent. Then there is also under section 71, and we will do, section 71 is with regard to any changes that you want to bring in the patent register. We'll discuss about these sections also in the subsequent slides. But all I'm saying is that anything that has to deal with section 64, which is regarding the revocation of a patent, or regarding section 71, if you have any grievance, if you want to do anything under these sections, you can go directly to the High Court and it will be an original jurisdiction. There is a form called Form 8, okay, and rupees 10,000 only. Now, this Form 8 is not the form which is listed in the Patent Act, okay, in the BEAR Act. No, this Form 8 is a part of the rules which you have to look at, and it's already there in the subsequent slide. I'll show you how. Second type of cases is the appeal cases, right? And therefore you call it as appellate jurisdiction, which means if your controller has decided on a certain matter already, let's say he has given directions to the co-owners of the patents, or he has given decision with regard to pre-grant opposition, and even the post-grant opposition, right? Section 25(2). If he has given decision regarding post-grant opposition, and which is where he found that the invention was wrongfully obtained by someone, and the patent should be granted or in the name of the true inventor, and the existing patent should be rather revoked. So any kind of controller decision which is listed under section 117A, these decisions against the controller can go to the Delhi High Court now. Okay. Now, why it is called as appellate jurisdiction? Because you are appealing against the decision of a lower authority, that has already rendered some decision. Which is that lower authority? The controller's decision. Where are you appealing it? To the Delhi High Court. What section are you appealing his judgments against, or his directions or his orders against? Are the orders that he has announced or he has given out under section 117A of the Indian Patent Act. We will look at what 117A entails, what all sections are covered under this. And the form for filing appeal suit is Form 9, and the amount of fees rupees 10,000. So this Form 9 is again not the form which is the part of your Patents Act. This is the form which is separate, which is listed as a part of the rules. Now let us go ahead. There has been also a lot of questions during the classes, and also when we as industry people sit together and we discuss what will be the right jurisdiction. For example, we only have today the Delhi High Court rules, right? Only Delhi High Court has set up an intellectual property division right now, and the rules have been announced. Now, suppose there is a controller decision from Maharashtra Patent Office, or there is a controller decision from Kolkata Patent Office, and you want to appeal against it. Where will you go, right? Would still Delhi be the right jurisdiction or not? Or would it only take care of the decisions of the controller that have been given out from Delhi Patent Office? So the clarity has been given with regard to jurisdiction, the right jurisdiction of the Delhi High Court. And it is listed in section 2L. Where is the section 2L? Not that of the Patent Act at all, certainly. It is a part of Delhi High Court IPD rules 2022, right? And if you look at the last paragraph, what does it say? All pending proceedings before the Intellectual Property Appellate Board relating to Delhi jurisdiction will be transferred to the Delhi High Court. So anything that has happened, suppose there is a patent filed at Delhi Patent Office basis the jurisdiction, and there is a controller decision on that. Those cases only can go to the Delhi High Court, and not any cases that you may want to flow from Maharashtra Patent Office or Kolkata or any other to the Delhi High Court. That cannot happen. So this is how jurisdiction of Delhi High Court is decided, and there is a clarity given already here, and you can at a later stage read complete section 2L of the Delhi High Court IPD rules 2022. Let us proceed further. So Delhi High Court IPD, original jurisdiction, when one approaches directly to the court, and like I already said that this is the original jurisdiction, you are going straight away to the court, and there is no lower authority that has ever rendered any decision. So I told you two sections, right? Section 64 and section 71. So what is section 64? These are the grounds of revocation, meaning on various grounds how you can revoke a patent. Now you can revoke a patent basis the fact that the invention was already previously claimed, that it is not novel, that it is already published by somebody else. You can also revoke the patent basis that it does not have the inventive step, that is the threshold of inventive step has not been complied with, or the patent specification are incomplete and the claims are not being supported by the complete specification. And there are several other grounds, right? And I will just quickly take you through all the grounds of section 64. I know we've done it in a great deal in the class as well, but for the benefit of all who are watching online through the stream, is that if there is a failure to disclose the biological information, you can revoke the patent on that ground also. You can also revoke it on the grounds that it has been wrongfully obtained. There has been a fraud, or the secrecy directions under section 35 were not taken care of, or there is sufficient description of the invention, meaning the best mode, the method of performing has not been properly detailed out. So this is section 64, and these are the the major grounds basis which you can revoke a patent. So if you find that there is a patent that needs to be revoked on any of these grounds under section 64, you can go straight away to the Delhi High Court now. Okay, and this is called as the original jurisdiction if you are filing a suit under section 64. Now, section 71. What is section 71 of the Patent Act? This is about any person who's aggrieved. Aggrieved of what? That there has been some omission or absence of a very important thing from the register, from the patent register, or the entry that has been made in the register is not sufficient, or there is some wrong entry that has crept in, or there is some error or defect in the patent register. If there is any person who is aggrieved of any of these issues under section 71 of the Patent Act, then also he can go directly to the Delhi High Court Intellectual Property Division and approach to the court, knock the door for a relief, for making any sort of a variation or deletion, any sort of edits in the register of patents. Okay, I hope so far so clear to all of you. Let us go ahead. This is Form 8. This is the original jurisdiction under Section 64 and 71 of the Patent Act. If you're going and filing a case in the court, then this is the Form 8 that you need to use. Once you look at the rules, in the groups, I've already shared with you the complete detailed set of rules. I'm sure that you've read them already. And there are links also that I'll show you at the end of the slide. But go through these forms. Okay, it's not that you'll be asked about how drafting of these forms. It will never happen. Like I've been telling you in the class, that you don't have to mug up any sort of forms, but you should be aware that which rule number is it which is applicable if you want to file a suit to the court under any of these two sections, either of these two sections. So this is Form 8, and it tells about the name, address, email, mobile number, full name. So this is the basic, and then there are other things that you have to mention, like full name of the advocate, the name and address of your patent agent, and then you have to tell the complete details about the patent which needs to be revoked. Suppose there is a patent that you are trying to revoke, you need to tell the registration number, title of the invention, date of application, and all those things. Then you have to also mention who the proprietor of the patent is, current status of the patent, anything with regard to what is happening with the patent right now. Then the interest of the petitioner, that why is this petition being filed? Why are you trying to revoke the patent, right? So you have to give your interest also to the court, so that they could understand what has led you to go to the court and seek for a relief. And then finally, you say the ground for seeking the revocation, like under Section 64, if you're trying to revoke, let's say, then under which specific ground of Section 64 you can mention that. So it's a pretty simple form, right? All you have to do is that anybody who becomes a patent agent later and you want to use this form, this is all available. And then you sign name of the advocate and go ahead with it. Now let's look at 117A of the Patent Act. I'm sure every day when you read the BEAR Act and we do these things in the classes, you must be always seeing appellate board still, because maybe your books are not the new ones. But the only difference that has happened in the Patent Act is this, that instead of appellate board, you read this as High Court. Similarly, when you read Section 64 and when you read 71, Section 71, read Intellectual Property Appellate Board. Instead of that, read it as Delhi High Court or the High Court, not Delhi High Court. So, sorry, you have to say High Court. So 117A appeals to High Court. Okay, and this is the whole section. Now under 117A, the decisions of the controller, that the controller that has rendered decisions under any of these sections, Section 15, 16, what is Section 16 related to? It is related to divisional patent application. Section 17, 18, 19, 20, Section 25, subsection 4, Section 28. We've done it very deeply in the class about Section 28. Then Section 51, which is related to the rights of the co-owners, or Section 54, which is related to patent of addition. So any of these sections that are, and then these all sections 84 to 94 are related to compulsory licensing and the licenses with regard to the domestic manufacture and the exports in terms of national emergency or extreme emergency. So these all sections, suppose there is a controller who has rendered decisions in under any of these sections, and if you are not happy with it, then you can go and file a suit straight away to the Delhi High Court. Okay, and this will be considered as the appellate jurisdiction, because you are appealing against someone's decision, against the decision of the lower authority. And then it says every appeal under this section shall be in a prescribed form. So this prescribed form is not any of the form which is listed in the Indian BEAR Act, okay, Patent Act. No, it is Form 9 of the Delhi High Court, and it shall be verified in a matter. So everything remains same. Only two changes that have happened in under Section 117A, as far as this section is concerned, is that instead of appellate board, read it as High Court. And whenever you read about prescribed form, there is no other form but the Form 9 of the Delhi High Court. So these are the sections. Let me just quickly take you through what are the sections I just mentioned to you about under 117A. Suppose there is a controller's decision that has refused the application. He has not granted your patent on the basis of that you could not satisfy him basis the questions that he asked you, and he refuses your patent. So you can go against the decision and file a case in the Delhi High Court. Then section 16 is controller's orders with regard to divisional patent application. Suppose you file a patent application and he asks you to divide it, and you are not happy with it, and you say that no, there is no need to divide my patent application. Every invention that I'm listing in my claims is linked to each other through a common inventive step. But he continues to say that no, you need to divide it. And if you're not happy with it, you can go to the High Court now. Where you were earlier going to the IPAB, you'll have to go to the High Court. Similarly, any order of the court regarding, order of the controller regarding post-dating of the application, section 17. So where you're not happy with the decision, you can go to the High Court now. Similarly, under section 18, which is order regarding complete specification, or where he has anticipation. He has anticipated that maybe your invention is already anticipated by some other publication and you're not happy with it, you can go to the court. Similarly, orders of the controller against the potential regarding potential infringement. That is where you have to put the reference with regard to the other's patent application, where controller feels that, okay, this might be a case of infringement at a later stage. So he might ask you to put a reference to that granted patent or any other that belongs to any other inventor. So that is section 19. Section 20 is regarding substitution of the applicants, and any order against the controller that you want to go, you can go to the court now, to the Delhi High Court. Similarly, orders regarding rendered under section 25(4) or section 28, which is regarding the mention of the inventor in the patent. Section 51, which is directions to the co-owners. Section 54, which is order regarding patent of addition, order regarding amendment of the patent or any specification or any other document under section 57. All of these you can go to the Delhi High Court and appeal against these decisions. Similarly, all listed sections in this slide, which is under section 60, 61, 63, which is order regarding surrender of patent. So if someone is surrendering a patent and the patent office is happy and controller says, okay, you surrender, but you are claiming that why should it be surrendered, right? Or vice versa. You can go against, if you're not happy against the decision of the controller, you can go to the High Court. Similarly, under all these sections, see, I just told you under section 84, compulsory license, or 85, 91, 92, 94. These all sections, I hope you have read it much in detail. It's only 1 month left. But anything that is under 117A, you can go to the High Court now, under the Delhi High Court IPD appellate jurisdiction. Now, this is Form 9, which is where you file appeals. This Form 9 is not that which is listed under the Patent Act, but under the IPD rules. It's almost the same here. It asks for a name, details. Then it also asks for the appeal under section 117A of the Patent Act, challenging the order of the controller, right? Dated, and you have to pass by the controller. You have to tell the name here and the date. When was this order released? Against which you are filing a suit, against which you are going and filing an appeal. And all the details here. You have to put the name of the advocate who will be taking care of the matter in the court, who will be prosecuting it, the name of the patent agent. You also have to give the date of the impugned order appealed against. So the controller ka jo order hai, that is what you have to mention here. Similarly, you have to also mention about the period of limitation. Are you under the limitation period, or have you not complied with it? So all those details will come here. I don't want to bore you with taking you through the details of it, but you know now what it is. It's Form 9, and you can go and use this form if any suit has to be filed under 117A. and then the list of documents that you have to mention. So you have to attach the order of the intellectual property office, and you also have to attach the any other relevant documents that form the part of the record. Now, Delhi High Court rules governing patent suits 2022. These are the rules which were published or which have been published specifically regarding the patent suits. Okay, what we were discussing before it were these suits regarding any of the under any of the act of the IPRs, copyright, trademark, geographical indication, what I showed you in the first and the second slide. But there are other rules also which are more specific to the patent suits. So like under 117A, or we discussed about 64 and 71, if you want to file a case or any other patent suit, let's say invalidation, revocation, and you are going ahead and filing a suit, then there is a whole set of detailed rules that have come out. For example, how the plaint should be written. What is plaint? It's the complaint which a patentee is going ahead with, or not. It could be other way around also, right? Plaint is filed by a plaintiff who is going and seeking a reprieve in the court, who is knocking the door of the court for some relief. It could be from either side, right? Related to patent as an issue. When the plaint has to be filed, how it has to be filed. These are complete details mentioned over there in the rules. Similarly, a written statement that has to be filed by the defendant party, his opinion onto that plaint, and then finally the replication, meaning which has consolidated views, and where finally the plaintiff is filing his case. So the complete details are written under this patent suit rules. So these are two different set of rules. Be careful and mindful of that part. Now, key highlights of Delhi High Court. So if you have any questions you want to ask, you can post it in the chat. Otherwise, we will be anyway discussing it in the class also that we will be doing in some time from now. So the key highlights with regard to this is there is a detailed procedure regarding invalidity claims and invalidity brief. Okay. And you've been asking on the groups also that whether you should go through the rules or not. I would say please go through the rules. You don't have to ratify it. You don't have to mug up anything, but you should have at least read these rules at least twice. And it doesn't take more than 20 minutes or half an hour to skim through it, right? But it will be very, very useful for you to respond to certain very basic questions. I don't expect very complex questions coming up in this exam, because this is a very, very fresh thing that has happened. Maybe in the subsequent examination, you might find a lot of hypothetical questions being created out of it. But in Viva, certainly, you might be asked of any of these questions, and you must read through these rules. Okay. Now, detailed procedure has been listed with regard to the invalidity claims and invalidity brief. So where you are going ahead and trying to invalidate the patent. And invalidation could be on any ground, right? It could be on under section 64. It could be under section 3, that it belongs to a non-patentable invention or invention related to atomic energy under section 4 of the Patent Act. So it says that there is an invalidity brief which should contain the prior art references, because when you are invalidating a patent, you are invalidating basis the ground or the reason that there is already a prior art existing. Okay, so any of the important details about the prior art references, you need to give those. Similarly, if defendant is relying on any prior art publication, then the reference should also be mentioned about it. Then invalidity brief shall contain a conclusive analysis. मतलब ऐसा नहीं कि आपने what you have done is that okay, you said that okay, invalidate this patent because there are list of prior art references. No, you have to show, you have to earmark how it is not novel, how it is not inventive in light of the prior art references that you are citing. Okay, so therefore it says that it has to be a conclusive analysis. It has to be a detailed analysis. Further on, these two things I've already explained you, invalidity under section 64 or 3 or 4. There has to be explanation with regard to the case laws that you can provide to the judge for the better understanding. Further, invalidity under any other section, And there are so many other sections under which you can invalidate a patent. You also have section 25. You've got, there are different grounds under which you can invalidate. So for example, there is a specific provision and grounds. Let's say you have to explain those grounds also in your explanation. Then it says that if any of the grounds of invalidity have already been dealt with by the patent office, like suppose Indian Patent Office has already dealt with the invalidity grounds under section 25(2), which is the post grant opposition, right? Then that decision of the IP also you have to attach, so that there is a clarity that okay, this was already dealt by and what was the decision. Now, there are also some key highlights with regard to claim construction brief. Now, what is claim construction brief, right? There is a construction of a claim wherein there is maybe there is an ambiguity in some claims, and it needs to be now construed as to the real meaning of, let's say, any word which is listed or the scope of any claim, right? If that has to happen, so those briefs have also to be given. Similarly, there is a complete detailed structure which is listed out with regard to the claims, like I just told you, the written statement or the counterclaim and replication. And I told you what replication is. So plaint is the one which is filed by the plaintiff, the first person who is going and knocking the door of the court for relief. Written statement is the statement of the other party against whom you are filing a case. Counterclaim is the party who is saying that, who's counterclaiming that, okay, I'm not infringing, rather your patent is invalid. Replication is again filed by, let's say, plaintiff, who then consolidates what he said, what is being stated by the other party, and his final opinion. And then the documents are to be filed alongside. There is a complete detail. If you read these rules now, you will find that there is a complete details written how these documents are to be prepared and drafted. Then any sort of licensing disclosure. Suppose if there is a dispute regarding licensing, so it also states that the appropriate licenses have to be redacted. Any confidential information has to be redacted. It has to be under the seal and cover. So all those details are already mentioned for all of you, which I really feel that you all should go through. Then there is a detailed procedure for first hearing in the suit and requirements for the case management suit. So these are the key highlights which are already provided, which you must go through. And then this is with regard to, so I think we are done with the IPD and how it was set up, what all are the forms listed, what are the cases that will go under original jurisdiction and under the appellate jurisdiction. I think these are a couple of last slides left, which we must go through quickly. So Patent Amendment Rules 2020, which came up on 4th November 2020. And these are rules related to Rule 7, Sub-Rule 3, wherein there is a table mentioned, and in the first schedule, there is a 80% waiver of the fee for 3 type of people, 3 categories of the patent filers. Either the person who is a natural person or a startup, or it's a small entity. If any applicant belongs to any of these 3 classes, then there is a straight subsidy, and there is a waiver of 80% of the fee that has to be filed by any of these. And then there is no difference in the scale of the fee. For example, if let's say after filing a patent application, the small entity ceases to be a small entity, it has become big. Still, there is no change that has to be there with regard to the fee waiver. 80% fee waiver would still be applicable, because at the time of the at the time of filing the patent application, it was a small entity. Any status later on doesn't matter. Okay. Then there is Rule 24C5, which allowed for the expedited examination. So if any of these 3 entities want to get their application expedited, wants to be picked up out of the row, they can get it done. Then there are Patent Amendment Rules 2021, which came up on 23rd September 2021. So there are 2 rules, right? Like we just discussed about rules that came up on 4th November 2020, and then other set of rules which came up on 23rd September 2021. This was with regard to the educational institutes. Any educational institute that belongs to Government of India that has been set up under the Central Act, and includes any other educational institutes as recognized by an authority designated by central government or state government or the union territory. So if an educational institute belongs to any of these categories, then there is a 80% fee rebate even for those educational institutes. Now it is being stated that the number of filings that you see today, it's 45% of domestic filings. It used to be 20% at one point in time. Then it came out to be 32%, and today it is 45%. And credit goes to such initiatives, right? Like the fee reduction for startup, for small entities, for educational institutes, a lot of awareness programs that are now going on across the country. So this has led to the increase, right? So these are the good rules to feel, good about it. And then certainly when you are asked in the question paper in the Viva, these are the answers that you can give with regard to when rules came up and what are the changes that that were brought out. Now, these are the documents for reading. This is the last slide, guys. These are the documents for reading. These have already been shared with you during the class. These are the 4 rules that I've just explained you, all of these in the entire presentation. Back home, please go and read through it. And any doubts that you have, let's get it clarified during the class. And I think I am done with it. You can join the Telegram group. Chetna, if you have your Telegram group link, I think you can post it now on the chat. But I think this is where we are. Now I think let's catch up in the class itself. Let me see if there are any live chats. Rohit Mishra is asking, Tribunal Reforms Ordinance is now Tribunal Reforms Act with effect from 4th April 2021. Right. Thank you, Rohit. Abhishek is writing, can you put some light on COVID-19 relaxations in the Patent Act and the examples? See, in the Patent Act, Abhishek, single, there is no change, right? Act has not been changed. Of course, there were waivers that Indian government has been asking at the WTO level, but those have not been materialized because during COVID-19, there are 14 to 15 voluntary licenses that have been signed up between the multinational, the IP owner, and the Indian generic company. So this has already happened, but in the relaxation with regard to Patent Act, there is nothing as such that I am aware of. Aman is asking, but what would happen in case a patent application made by a startup is acquired by a large company in a merger and acquisition transaction? Aman, happen what in case of what patent application? Because let's say if a startup has been acquired by a large company, I'm sure that there'll be an assignment, right? It will assign it to the company that has acquired the startup. Then the applicant name will change, and the assignment has to be given to the in written document to the patent office. I hope I have clarified your question, but if not, please do ask again, and we can get in touch, Aman, again later on after this live stream is done. Nisha is asking, please clarify jurisdiction. Last clause of section 2L, which mentions pending IPAB cases to be transferred to IPT Delhi High Court. What about new cases which anybody wants to file for the controller order from Mumbai, Chennai, Kolkata, and patent office? So Nisha, like I said, right now we have rules from the Delhi High Court. Okay, na? Soon we are expecting the rules to come from the other courts also. And I'm sure they will also detail out the jurisdiction. As far as Delhi High Court jurisdiction is concerned, it is only with regard to the controller's decision that are emanating from the Delhi Patent Office. So once you go through the section 2L, you will get to know. Kevin, what about other jurisdiction? IPAB is still functional in all jurisdictions other than Delhi? No, Kevin, IPAB is completely zero, right? There is nothing happening there. It's closed down. It is only Delhi High Court for now. And then soon we are expecting, like I told Nisha, the other high courts are also coming up with their rules. Soon we should be able to see it. Okay. Can a patent agent do patent prosecution in Delhi High Court? You have to be an advocate, right? If you don't have a LLB degree, if you are not registered with the Bar Council of India, you cannot prosecute. A patent agent with a law degree and registration with the BCD, if you want to prosecute in Delhi High Court or any other state, then you have to be registered under it. So you need to have that qualification. If not, then you cannot. Karthik, IPAB is not functioning anywhere. Yeah, right. Thank you, Karthik, for clarifying. And this is what I also stated. Delhi High Court has formulated its own IPD, which can be understood as an internal arrangement. Other high courts are coming up with their own rules. So this is what exactly I told you. Until then, all suits transferred from IPB will be dealt by the original side and appellate side of the respective high courts. So we'll have to wait for the high courts to come up with it. Aman, I think Aman is saying that I think the relaxation Abhishek is talking about is in the form of extension of timelines applicable under Rule 6.6 of the patent rules. Okay. So Aman, if you have more details about it, maybe paste it into the chat box. I think it will really help Abhishek know better about it. Oh, so you're mentioning about the extension with regard to filing the suits in the court, right? Yes, there was an extension because the courts were not functioning at that time. These were all closed down. But I think now the courts are back to the normal system. So there was relaxation for sure. The limitation period was extended. Aman, you can provide more details. Yes, so Aman is also giving more information that Madras High Court has already started the process of formulating its own rules. I'm sure whatever Delhi High Court has done, the other high courts are also encouraged and inspired to come up with their own. Anshu Raval, pending cases before other high courts, Kolkata, Mumbai, Chennai, etc. So this answer I've already given. I don't see any other live chats. Well, thank you so much, everyone. And let us see you all in the class now. We'll close it from here and see you back. Okay, bye-bye. Thank you so much. Study well, study very hard. I'm sure you all will crack the exam this time. Bye-bye.